Hello viewers, welcome to the legal vlog. My name is Naiza Barbara. If you're new here, kindly subscribe to our YouTube channel, like and comment for more legal updates. So today we are going to talk about wills in Uganda, who can write a will and what do you have to put in your will. Lero tugenda kwogera ku ddaame ani akkirizibwa okuwandiika eddaame mu Uganda ate na biki by'oyinza okuteeka mu ddaame gy'oyagala okukola. So let's start by defining the term a will. A will is a legal document expressing how you would want or how you would like to distribute, govern your property, estate or assets upon the time of your death. So we must know that a will only works upon your death, upon your demise. So if you're still alive and you made your will will only work upon your death. It's only upon death that the person you gave your will to will come out to your family or to the public and be like, so and so, this is how he or she wanted to distribute his or her properties upon your death. So let's look at who can write a will. Are you in position to write a will? You must know these few things before you write a will. So every person of sound mind and not a minor may by will dispose of his or her property. So if you're a person of sound mind, we mean someone who is not insane, someone who is not intoxicated, someone who is not drunk, someone who understands what he or she is going to write. So that's the person of sound mind. And then a minor is someone who is below the age of 18. That person cannot by law write a will. So you must be someone who is above the age of 18 and a person of sound mind. So another thing is that you must have property, because we've said that a will is for distribution of property, is how you want your properties to be distributed upon your death. So if I told you don't have property, what are you going to distribute? Why are you writing a will if I told you don't have any property to distribute of? So a will only works when you have properties to distribute of, or the properties you want to distribute of upon your death. So for there to be a valid will, you must have properties, and properties in your names, not your neighbor's property, not your friend's properties, or not your father's property, but it has to be your property. It can you cannot, if I told you write a will and you put your brother's properties or your neighbor's property in your will, then that will be challenged, and then your properties will be distributed according to the Succession Act as amended. Yes, so ordinarily a person who is insane, ordinarily, like when you're not totally insane, when you're on and off, so that person can be allowed also to make a will if at all he or she understands what he or she is going to put down in the will. He can only write a will during his sane capacity, but the moment that person goes insane, then he cannot write a will. If he comes back to normal, he or she can write a will. Yes, so basically those are the things you need to know about writing a will. We've talked about what is a will and who can make a will. There are few things in this video. I don't want to make it a long video. I just want us to understand step by step. We shall make another video in details for other things in regards to making a will, but for this video we are stopping on what is a will and who can make a will. So we've said someone who is of sound mind, above 18, and that person must have properties to distribute of. So